8:30, right? For Jensen? Okay.
He's back there if you want to talk.
Okay.
Is that a jury room? Yes. Nancy, you remember where the jury room is, right?
Oh, I do.
Oh, yeah. Deja vu, isn't it?
I know. 10 years of using this room. I should know where it is. Did she say yes?
Oh, perfect. So they, thank you.
I hear you. My best. Can you give me a look? Okay, thank you.
Well, not so much in here, but
Right.
I'm in and out. So.
I'm ready to go home.
You
did not be years old.
How's your, is it your nephew I'm friends with on Facebook?
Also friend?
Yeah.
could be me.
Okay, I'm a friend of you.
Yeah, and the other Frank is my son.
They're in the back, they're in the jury room.
Kind of alone for a second.
Yeah. Not even a fleet. Not long. Innocent.
You had to find a charger last time I was here. Oh, there it is. Still seeing.
Is it still sitting?
There we go.
It shows you how much we look at the. Oh, you're lucky.
That thing has been sitting there for how long?
Since last time we had a hearing judge.
We didn't touch it.
I appreciate that.
Didn't even, yeah, I don't look at the desk.
Oh, thank you. David, yours.
We found, Mackenzie left her red folder here. We found that.
Well, that's hilarious.
But we
We
didn't see
finally
the
solved
charge.
the mystery.
I had another one at home, but I was like,
We're gonna put it under the mat. Oh, I'm glad at least we got it though.
Which is, so now I rely, I got to be I thought my due diligence was.
okay, all right. He's in the back already.
I know, because I thought that's my job.
Okay, thank you.
And I did it twice. That's okay. I'll just take your word for it. I don't want to see this. Oh, yeah.
We'll do that.
So,
Okay.
Okay.
So
gonna say, well, yeah, that's the smartest move.
Besides Mary her,
Yes.
smartest thing you ever did.
I saw it there. I was trying to get rid of it.
We need another chair. Okay. Yeah, that's fine, that's fine.
Well, right, I get it. So he can't debate.
Oh, yeah.
Yeah, I was gonna say, good luck with that.
Just see it right.
Yeah, I think so. Yeah, I mean, there's so many seats down here.
Oh,
Maybe we
here,
can
can sit right there.
Joel, did you meet with this?
as long as we're not blocking.
Yeah, yeah. Thank you.
Yeah. Yeah, I can't. For some reason, I can't hook up the internet over
Yeah,
here.
this could be quick. New day.
Tired, how are you?
I'm not getting behind this.
Oh, no. So what time did you?
So,
I don't know if it's gonna call.
New date, yeah. I think we have to wait for Brenda. We gotta wait for prosecutor.
wait for Brenda.
Yeah, we gotta wait for
Let's
Brenda.
have her sit right there.
Okay.
We'll sit here, both of us. Did you wanna look for a date now?
March 8th, 10 o'clock?
March 8th, 10 o'clock, okay.
How's that? That's a Wednesday?
What's that?
It's a Wednesday?
Is the 10th available?
March 10th at 10?
Sure. Yeah, we have to wait for Brenda.
he coming? He's here. Yeah. Is your client coming?
Yeah, he's back here, sorry.
Oh,
He's in the red.
Yeah, bring him up.
Okay.
You'll just have to scoot out of it. But I don't see why they, there's no jury, just go to the seat. Yeah.
No.
It's green.
You got a supply of them.
Absolutely.
You guys want more chairs? It's gonna be a while. Could be. There's. Joe, we get chairs.
You need one?
Get another chair. Let's see. You need one more chair. You won't go through that way? On the back? Where? She can. Oh, good, okay.
All right, we're going to call number 2, Mark Jensen, 2002 CF 314. Let's have the appearances, please.
The state appears by Carly McNeil and Special Prosecutor Bob Jamboy.
Attorney Bridget Krause, Jeremy Perry, and Mackenzie Renner appear on behalf of Mr. Mark Jensen, who appears in person in custody. Good morning, Judge.
We have victim notification from the state.
We are in compliance.
All right. We are here for a final pretrial. We have a jury trial date of January 9th. We have some motions that have to be decided. I went through all the letters and the briefs and all the documents that were filed as to the motions, and I'm just going to go through them right now. The first one that I want to deal with is the testimony that was in the original trial, which I will call Jensen 1. The transcript has been provided. I'm dealing with a letter that was dated December 15th, 2022. It's on the issue of the termination of Maureen Levin, who was the Pryor County's medical examiner. The transcripts that were provided from the original trial, there was a question to Dr. Malin that says, "You knew at the time you were hired that Dr. Levin had been fired from her position." Yes, and that she was fired for conduct in this very case. She goes on to answer under oath, "I heard that may have been a factor. I really don't have access to her personnel file, so I don't know the whole case against Dr. Levin, to be honest." The next question was, when you took the job, there's something you were interested or why Dr. Levin left that position, right? The answer was, well, we're all kind of nosy, but I did not know. I did not go and inquire of the personnel department why they fired her. The next question was asked, and her answer was, "I heard the scuttlebutt that occurred. I heard the scuttlebutt." So, I mean, that's all. We're on the record. Thank you. Obviously, that's all speculation. She has no knowledge of why this doctor was fired, and she admitted it under oath. In court, it's not like she's given some sort of statement to one of the attorneys. She's basically saying, "I don't know anything. I'm speculating." It's all scuttlebutt, so that line of questioning is not going to come in.
Judge, can I ask for a clarification? Is the
No, we're going to make decisions today, okay?
Want to make sure that
I just said no.
don't know specifically.
It's not coming in. All right. Here's the important motion today, and that is the decision that I'm going to indicate for the record, Jensen 1 and Jensen 2. State versus Jensen, 299, Wisconsin 2nd, 267. And State versus Jensen, 331, Wisconsin 2nd, 440. They're both identical as to the letter. And they ruled that the letter was testimonial. And they both ruled that the statements made by Julie to Kosman, who was a police officer for Pleasant Prairie, including the letter addressed to the police, are testimonial. So that letter, those statements, it's not coming in at all. I'm not the Supreme Court. I'm not the Court of Appeals. This is the law of the land. It's not coming in. But all the other non-testimonial statements, and the testimony, it was in the first trial. It says here, the statements Julie made to her neighbor, it talks about Wojt, W-O-J-T, her son's teacher, DeFazio, all those non-testimonial statements that are in Jensen 2, which is 331 Wisconsin 2nd, 440. They're coming in. That's a distinction. And that's the law, and that's what's going to be going to happen at the trial. And if anybody does anything different, they'll pay the consequences. And it's the same principle. For this expert that the defense has. The who's the expert that used the letter that the defense is using?
That reviewed it, Dr. Sarah West.
What's it?
Dr. Sarah West.
All right. Now, I read State versus Thomas, 399 Wisconsin 2nd, 277, and it talks about that the state shouldn't have an opportunity to bring in this inadmissible evidence through some sort of back door. They can't get it in through the front door, so they shouldn't get it in through the back door. I know that the expert looked at the letter and used it in their opinion, but if we look at page 305 of the decision, it talks about the Supreme Court quoting Professor Dave Blinko, who's well respected. It says, problems arise. If I do give some sort of limiting instruction, which the state is asking here, it's meaningless. It says, the jury's going to know about it then. I know Mr. Jamboys gave me a limiting instruction that said it's only going to be used for limited purposes, but the jury's going to know. And I think limiting instructions sometimes, I agree with Professor Blinka, are worthless. They get to hear it then. And then I'm going to tell them they can't consider it for the truth of the matter or the guilt or innocence of the defendant, but it's already in. So to be consistent with Jensen 1 and Jensen 2, that this letter and all the statements that were ruled testimonial are not coming in, we're not going to get into it with the expert either. Ms. McNeil, you wrote me a letter on Mr. Klug. Did you get that disc that you were waiting for yet from the prosecutor?
I have not gotten it yet. I think it was put in the mail sometime Tuesday.
All right, I'm going to reserve that until you get that disc, because I did make the ruling on it. The other ruling that I wanted to make today, and I'm going to reserve it, I still haven't determined what to do with it because it's not an easy issue, is this letter that Mr. Jamboys wrote to the prior attorney that the state wants to use when they cross Dr. Long. So,
The state doesn't want to use it, the defense wants to use it.
I'm sorry, you're correct, Mr. Jamboys. The defense wants to use. That's a very close call, and I'm going to wait to make that decision. I mean, I don't think it's going to be a major problem for the attorneys if I rule one way or the other. So, okay. Any other motions that I missed that I was supposed to decide from the state?
Yeah, I don't think so.
Any motions I missed from the defense that I didn't decide?
No, Judge.
Okay. Next thing we're going to cover is when we do come back for the trial, we're going to have 80 jurors here. We're going to seat 28 jurors. We're going to have 4 alternates. Each side will have 6 strikes. To have no issues as to any prior publicity or some sort of issues of prior knowledge about this case. I'm going to have 10 jurors come over at a time. The others will be in another location, and each side will get to ask 5 questions as to prior knowledge and publicity to these 10 jurors. And if we have any issues, those jurors will be excused so they won't poison the whole 80. The other ones that we will keep will go to another location, and we will go through all 80 then 10 at a time. Once we've completed that, we'll bring everybody back and we'll do the regular voir dire. I don't want to have all 80 in this courtroom and then somebody starts talking about prior knowledge and then we have a problem with that whole pool. Any problems with that from the state?
So, Judge, I'm just looking at 972.03 for the peremptory challenges, and it looks like because this is a life imprisonment trial, then each side gets 6 strikes, as you had mentioned.
Right.
And then I'm just reading a little bit further on in the statute, and I think it says if there are going to be alternate jurors, then each side is allowed 1 additional peremptory
Then we'll go to
challenge.
7 and we'll put 30 in the box. That should solve it.
Yes,
right?
I agree with 7. Thank you.
All right, so I'll change my ruling. We'll have 30 in the box and we'll have 7 strikes apiece.
And, Your Honor, were you planning on having the jury selection in this courtroom, or were we going to go to branch 3 for the jury
Every other
selection?
judge has a jury trial going that day.
Oh, so we're going to be doing it in this branch.
That's a busy week.
Okay, I was just wondering.
And I know you turned around, there's not a lot of room here. We're going to have to somehow live with it.
Okay. All right.
So I asked the state, any problems with doing 10 at a time?
No, Your Honor.
Any problems with the defense?
No, Judge.
All right. The next thing to help the, I'm sorry.
So there'd be 10 in the box, the rest of the panel would be all seated behind us.
No, the rest of the panel are going to be in a different location. We'll put 10 in the box. We finished with this 10, they go to another location, we bring another 10 out until we're done with all the 80. And then whoever's been knocked out won't come back, and we'll bring everybody back that just passed the first voir dire
So we'll
test.
do like 8 voir dires, is 10 at a time.
Right,
so it'd
we'll
be
do it 8
voir dires.
times.
Okay.
But just the limited voir dire
Right.
as to the publicity, and then the big voir dire will be everybody else, yes.
And again, 5 questions apiece. We're not going to hammer them with 100 questions. And I think I've done it before. The 5 questions, you can get right to the point.
Yes. So each side gets 5 questions during voir dire?
Right, for the first voir dire. The second voir dire, we're back to the normal, whatever questions you wish to ask. This way, we're not going to have any problems.
Okay.
Okay, because of the tremendous amount of exhibits in this case, I want both sides, this doesn't mean you're going to have to, you're going to use the exhibit, to make a list of their potential exhibits, because it would help the court and the clerk to know that.
Okay, just the list of the exhibits, not to actually produce the exhibits themselves?
No,
Yes?
just a list, just give us a list.
Okay.
Judge, as to exhibits, is there a specific number that we're going to start with, or are we just going to alternate as we're going? Like, is the prosecution going to start with 1 and we're going to start with 200, or?
But, yeah, you'll have to figure out how many exhibits you have, and the prosecution they have to go in order.
Okay. So they'll do theirs, and then ours will be after
After what-
that?
yeah.
Okay.
If you let them know.
Obviously, the parties are aware of the press and the live feeds that are going to happen during this trial. We're not going to have any photographs or live TV cameras when we do the voir dire. The only way the press can do that is through audio. I'm not going to have a issue where they're filming the jury during voir dire. There's just too many issues. So once that phase is completed, the media can do their normal activity. The other rule that I wanted to enforce during the trial, and this is for the attorneys to tell their witnesses or whoever's going to be here for the trial, once we start the trial, if somebody wants to leave, they are free to leave, but they're not going to go back in and out. This door is right by the front door of the court entrance. You open this door during the day, you cannot hear what is going on. So you could be in here, it's open court, but if you have to leave, you're going to have to wait for a break to come back. I don't want people coming in and out, in and out. It's just terrible for the record being made. Okay, anything that the state wants me to address further on this case?
So last time we had indicated to the court that we wished our investigator to be accepted from the exclusion order, and we
He's
still.
going to have to bring his own chair. There's no more chairs.
He can sit on the floor.
All right.
So I think the only other person that the state would request is there might be brothers of Julie Jensen who would like to watch at least parts of the trial. And they are also listed as witnesses, but I believe they should be accepted from the exclusion order as victims under the definition. They do meet the definition because they are siblings of the deceased person.
Defense has no objection to that.
What's that?
We have no objection to that.
All right, thank you.
And so I believe there's 4 brothers that we have listed, and so each of those is what we're requesting.
Anything I missed from the defense?
Judge, the only, there's 2 things that I'd ask the court. Number one, is there a way to get one, I don't know if there is, one table? We have a lot of exhibits and it's going to be hard.
You mean an extra table?
Either an extra table or, I'm just concerned because of the volume of transcripts and exhibits in this case that there's physically not enough room on the tables to deal with that. I don't know if that's possible, but I just wanted to ask.
We could move something
Yeah.
up front here.
A folding table, and we could,
We could put one up here maybe.
Okay. And then the second thing is, I know the court ruled that the manuscript as described by the prosecution was admissible and denied the motion to reconsider. Within the pages that were filed by the prosecution within the last week, one of those includes the actual letter. And I assume that based upon the court's previous ruling that that would not be allowed.
The letter's not coming in.
I understand the court's ruling, Your Honor.
I don't want to keep talking about it.
Yep.
I'm not the Supreme Court. I don't want to be on a Supreme Court.
That was the only other thing that had recently been filed after the last motion hearing that I just wanted to clarify. Some additional stuff was filed yesterday, but I believe we're going to be able to work that out. I just have to finish reviewing the transcripts that were provided.
All right. I do have one more thing to say. Both sides filed an order from the last hearing. I didn't hear any objection from either side, so which order do you want me to sign?
So I'm
I'm talking about the order about what was decided on November 21st. So I got one from the state, and then I got one from the defense.
So, Judge, somehow we must have missed the defense's order. I did not see it. And so when I saw the entry into CCAP of the order, I thought it was mine. So that is.
So we haven't seen the defense
Yeah,
order.
that's-
Could we see it? It's,
It's
E-file.
filed.
And I would ask the court to sign the defense. I think it's simple and just states
That's-
exactly.
I don't want to get into that argument.
That's fine.
You know, you guys got to work that out.
Well, perhaps we can do a joint combined order after the
That would be
rulings
wonderful.
today. Okay. Sorry about that confusion, Judge.
So have that done prior to January 9th. Okay, again, I still have the one limited issue that I will decide on that day. Okay, anything else before we're adjourned from the state?
No, Your Honor.
Anything else from the defense that we're adjourned?
Nothing, Judge. Thank you.
Thank you.
I did too.
I guess we're done.
Now,
We can continue, and I told me.
try.
Yeah, I did. I gotta see what attorney's here.
Give me that look.
Joe, did Chris Rose check in? Okay, so we don't want Campbell, we don't want Branch Campbell. Okay. Okay, so 9/15. Yep. January 9th is the trial.
Yeah, and then we should just make sure we're. Right, and it sounds like we have.
Thank you, Mackenzie.